Hello everyone, welcome to Landmark Chambers webinar on assisted dying. A few housekeeping notes, your microphones are muted. We welcome questions throughout. We'll get them on one of the laptops and we can address them at the end. And we'll endeavour to answer as many as we can. The webinar is going to be recorded and you receive a link afterwards along with various materials. If you lose connection, try and rejoin, and Anushka, one of our helpers, will try and one of our admin staff will try and join you back in. So we're in a happy position that we arranged this webinar a week or so ago, and the terminally ill assisted dying bill has been adults end of life bill, terminally ill adults end of life bill 2024 has been published today. So we've all had a chance to whiz through it, and we're going to come on to discuss that. I'm joined today to my right by Lord Mance, a former judge of the Supreme Court, who decided the last major case that went before the Supreme Court called Nicholson about assisted dying, and has also spoken about assisted dying in his capacity in the House of Lords. I'm going to ask the other guests to introduce themselves. So to my far right, Fiona Scolding KC.
Hello, I'm Fiona Scolding. I'm a barrister in practice at Landmark Chambers, and I have done an extensive amount of work in the area of healthcare law over the past 25 years.
To my left is Rebecca Wilcox.
Hello, I am a television presenter and rather a rose between more rosy people. My mother is Esther Ranson and has signed up to Dignitas. So I'm here to talk about our position in the campaign and how we have felt about it. It's more of a commenting rather than anything intellectual. I apologise.
And behind me is David Locke KC, or on screen for those of you. David, would you introduce yourself?
Yes, I'm David Locke. I'm a Silk at Landmark, and I've been doing healthcare work for about as long as Fiona, and I sat for 10 years on the BMA Ethics Committee as an expert member. And I also have experience of having been accidentally elected to Parliament in the past, and therefore have some understanding of the parliamentary process.
Thank you. So we're going to be talking today about all of the issues that arise from the bill. We're not adopting any position, with the exception of Rebecca, who obviously has a position, but the rest of us, I think, just make that clear. Okay. I want to begin really with some of the background to the current legal position. Fiona, I was hoping you could explain to us what's the current legal position, starting off with Section 2 of the Suicide Act 1961.
Yes, well, obviously until 1961, suicide was a criminal offence. So in 1961, suicide was decriminalised, but the Suicide Act 1961 in effect provides that any person who aids, abets, counsels or procures the suicide of another, or an attempt for someone to commit suicide, can be liable for imprisonment for up to 14 years. Now, in reality, over the past 20 years at the very least, and certainly following the House of Lords, following the decision in the Supreme Court, both in the case of Purdy and in the case of Nicholson, the DPP, the Director of Public Prosecutions, has issued some guidance for prosecutors about when this will or won't be prosecuted. In effect, it sets out a number of factors pointing both for and against prosecution. But if somebody has, in effect, reached a voluntary decision to commit suicide, and the rationale behind the person assisting that was motivated solely by compassion, then it is unlikely that somebody will be prosecuted. And this guidance was issued in 2014, really in between sort of Purdy and Nicholson, in the light of the fact that it was felt that those people who went, for example, to Dignitas may not need to be the subject of prosecution, but they still may be investigated, and there have been 187 cases referred to the Crown Prosecution Service in the past 15 years. 127 of them were not proceeded with, 6 are ongoing, and in 4 cases there have been successful prosecutions. But obviously for them to have been referred to the CPS, that does mean that people have been investigated by the police and decisions made. So for those people who do make that choice to accompany their loved ones to Switzerland, which is the obvious jurisdiction in which one would do those things, there is a risk that when they return to Heathrow, they will be met by police officers and will be subject to an investigation, which can be fairly lengthy in nature, even if ultimately no prosecution is made. So it's a situation which many family members are quite naturally very uncomfortable with and would wish to change.
So in the 1961 Act, we see in section 1, it says the offence of committing suicide is abrogated, meaning abolished. But it kept the offence of assisting suicide.
Yes.
So you have quite an unusual situation now where to assist someone to do something that is completely lawful is a criminal offence.
Yes, but there are circumstances in which we would all recognise that it's important to maintain that offence. Say, for example, websites that encourage young people to self-harm and kill themselves. So there are kind of we would like to think there are, but there are a number, for example, of pro-suicide websites where young people who are extremely unhappy will come on it, and other people will literally say, oh, why don't you do it? Why don't you do it doing this? Why don't you do it doing that? So one would not want to decriminalise those aspects. And in fact, what the proposed bill says about it is there will be an exemption from prosecution if somebody is acting under the terms of the assisted dying bill. But I still think there will be circumstances, whether by coercion or duress or by improper pressure, where it is still necessary to mark by way of criminal offence some aspects of suicide or encouraging people to commit suicide.
Okay. Now, before we move on, can we just clear up some of the terminology? And again,
Yes.
Fiona, can I ask you, so if you could just distinguish some of the terms: assisted suicide, assisted dying, palliative care.
Okay, well, palliative care is simply care that is provided. It is multidisciplinary care, which is provided by a range of clinicians when somebody has a life-limiting condition. So you can have palliative care and still have decades to live, but it's just that your condition will ultimately lead to your death. So, for example, children can be subject to palliative care if, for example, they have complex epilepsy disorders, which therefore means they might suddenly die in childhood. They would be the subject of palliative care. So that's what palliative care is. And it's a term designed to be used not just to encompass doctors, but also specialist nurses, bereavement support, counselling support, occupational therapists, speech and language therapists, dietitians, all the people that people might need if they have ongoing chronic life-limiting conditions. Assisted dying and assisted suicide are, well, I would see them as two sides of the same coin. It's helping somebody else to die. Some people would say that assisting dying is what encompasses a wider group, because it could be the doctor themselves administering the drug rather than having the person do it for themselves. But I think those terms are used pretty loosely and interchangeably in reality in the discussion and debate that there's been so far.
Okay. So at the moment we've got in the UK, suicide is legal, assisting suicide is prohibited in all circumstances. There's the DPP guidance on when people might be prosecuted. And then there's another category, which is people who can travel abroad. And I was going to bring Rebecca in on that. So I think probably everyone's heard about the positions that abroad, including in Switzerland and Dignitas. Do you want to tell us about your situation in that regard?
I do. I have a question for Fiona. Is that for later?
Tell us about your and then we'll
it was great. It was just on the distinction between assisted dying and assisted suicide, because in the press that we're doing at the moment, we have always used assisted dying because the person is already dying rather than committing suicide. But the legal framework is so much more interesting to me and specific, and I've clearly been using it wrong, specifically on Sky Today. But our situation was my mother went on the Today programme on Radio 4 and announced to the world that she had signed up to Dignitas. If you think she told me that before she went, you would be mistaken. And the first thing I heard about it was a journo ringing me to say, how do you feel about it? She has always said that if the joy it has gone from her life, or the pain supersedes the joy, that she would fly to Zurich. We have looked into it, and it is not the facility that anyone would choose. And I'm interested that we are outsourcing death to it in such a prolific way, relative to the numbers that there are involved with this, because it looks a bit like a car park. I don't know whether you've seen it. It's not a nice process. There's many rooms. It could be an EasyJet hotel. I've stayed in many of them. And it would be without the bed and breakfast, as my mum says, because she would just be there for the bed. This is dark humour that gets us through this. She was diagnosed 18 months ago. At that time, we thought she had a matter of weeks to live. As it turns out, the chemotherapy drug that she is on has helped hugely and has kept her in a holding pattern, as she says, rather than circling the drain. She's flying above us. Again, metaphors that she likes to bring up that would not suit you, Alex. I'm sorry. So our problem is that, as Fiona said, if we accompany her to Switzerland, especially because our case has been talked about relatively widely, we would very likely be investigated when we land back in Heathrow with whatever container mum is then in. Delightful. And the thought of the 2-year prosecution process, for me as Deputy President of Childline, my brother as a doctor, and my sister, former social worker, hugely unwell, and it just doesn't suit us. I don't know who it suits. Certainly there was the case in the report of the 2 sisters that accompanied their mother to Switzerland, and upon landing they were investigated for 2 years. Obviously they talked to their colleagues, their bosses, everybody, and one of the sisters attempted suicide. So I think there is a horrible irony there that needs to be dealt with. I don't think whatever is the law at the moment is working. It won't work for our family. It obviously won't come into play to suit us. So I am very much facing a choice of letting my mother fly there by herself and my sister return. She's in a wheelchair. I don't know how. The details are impossible for me. I can't obviously say I would go with her because, well, you would know. Would I get arrested now if I said that? I mean, I would love to know whether I can still be me and go to Switzerland with mum.
Yeah, well, that brings us back to the DPP guidance. I mean, do you want to just quickly summarise what that is in terms of the prosecution policy?
Well, in effect, it quite carefully doesn't say these are circumstances in which we will prosecute and these are circumstances in which we shall not. But it says you have to investigate everything thoroughly, and there are various factors which point to prosecution, i.e. coercion, i.e. undue influence, i.e. that, and there are certain factors which point against it, i.e. the person has clearly identified a capacitous wish to end their life, the person is only motivated by compassion, it's obviously something which has been done with an immense amount of care and thought, but obviously that is an individual decision for the individual prosecutor, and no amount of guidance will ever say yes you will be prosecuted or no you won't, because so much depends on context and fact.
Okay, so we're just building up the picture of this current situation. We've got Section 2 makes it an offence to assist suicide. There are no exceptions to that in law. There's this guidance that we've just heard about when you might in fact be prosecuted or not, which is fairly flexible. And we've got the option for some people who can afford it, have the physical ability to do so, for whom it suits them to go to Switzerland. That's our current framework. The other component of it then is, where does human rights or where do fundamental rights take us? And that was a question that arose in the context of the cases of Mr. Nickinson, whose case then went forward after he died to the Supreme Court through his wife, Mrs. Nickinson, and a co-claimant called Mr. Lamb, and someone called Martin, who was anonymised but known as Martin in the case. This was a case that came before the Supreme Court, and Lord Mance was on the panel. It's a fairly unusual case, as I understand it, Lord Mance, and that there were 9 judges. That's not a particularly common composition of the court.
That's right.
Normally we get 5, and it says somewhere in the judgments that you deliberated for 6 months with an unusual degree of intensity. So I think it was a fairly unusual case in that respect.
Absolutely. I think that's Lord Wilson's phrase.
And so briefly, the facts there were that Nicholson and and all the appellants had irreversible disabilities. Nicholson could only communicate with his eyelids, and they sought declarations that the common law defence of necessity would be available to somebody who helped them to end their life. Alternatively, that Section 2 of the Suicide Act was incompatible with Article 8 of the European Convention on Human Rights that's incorporated through Human Rights Act 1998. Martin sought against the Director of Public Prosecutions an order requiring him to clarify the guidance that was in place at the time. So the first issue was whether the court was empowered to declare the statute incompatible with Article 8. Would you like to explain what that issue was and how that was decided, Lord Mance?
Yes, let me just start with a linguistic point which feeds into the case, and that is that there is a distinction between, and it's not just a linguistic distinction, I think it's a distinction of principle, between assisted dying in the sense of the sufferer receiving assistance to enable the sufferer, by the sufferer's own decision, to administer a fatal substance. That, I think, is properly described as assisted dying. And on the other hand, physician-administered drug, which I think crosses a line because there, the actual decision to administer and the physical act is the physician's own. I think in the Netherlands that both are, at least to a degree, lawful, and they're both subsumed under the same nomenclature. But I think that's confusing. I think there is a clear distinction in law generally, not just in this field, between enabling somebody else to take a critical act. You don't then commit the act yourself. You may be giving assistance to their committing the act on the one hand, and taking over the act and administering it yourself. So on that basis, one should limit what one understands by assisted dying, or at least be clear. Now, Nicholson actually started off as a case within the physician-administered drug category, euthanasia, one might say. In the courts below, it was thought not to be possible to provide any machine which would enable Mr. Nicholson himself to execute the decision he'd made. So the argument was basically in favor of what I would call euthanasia. Whereas when it came to us in the Supreme Court, the emphasis shifted. It was now thought that there could be a machine, that the machine would work, and that this could be presented as a case of assisted dying. But that was not a very satisfactory position. And if you read my judgment, it may appear a bit technical in the first part, but I think it meant effectively that we had no evidential basis on which really to consider the point which was now being stressed for us.
So explain, the machine could read the blinking of his eyelids, wasn't
Yes,
it? So that
that's right.
He could confirm
Yeah.
consent, and
So-
then it would automatically administer the drug.
So in one sense, Nicholson was a case where there were actually, at our level, technical problems in about the way the case had been conducted below, which I think made it very unsatisfactory, or would have made it very unsatisfactory to decide in favour of Mr. Nicholson. But nonetheless, at a higher level of principle also, we felt that considerations of institutional respect and relations between the legislature and the judiciary meant that we should leave the case for decision, at least in the first instance, in Parliament. And Parliament did, in fact, consider the position. It ruled against any amendment of the law. That then was challenged in another case called Conway, which came up and was refused permission by the Supreme Court. So the position at the legal level is that the case failed in Nicholson because of those considerations. It only failed fairly narrowly. I mean, there were two members of the court in Nicholson who would have felt able to make a decision that the present law was unjust, unfair, and should be rectified, but the majority of the court was either against any intervention at all, or in the case of three of us, Lord Nichols, Lord Newberger, Lord Wilson, and myself, in favour of the proposition that there could be circumstances in which courts had a role, but these were not they. These were not them. Since Nicholson, the scene has changed actually quite radically, because in a subsequent, more recent case called Elan Kane, the Supreme Court, which has obviously changed in constitution, in membership, has decided that the premise on which Nicholson proceeded was false. The premise on which we proceeded itself went back to another case called Re-G in 2008, and was that in cases which in Strasbourg would we meet with an answer from the European Court of Human Rights that there was no pan-European answer to the question, right or wrong, or whether assisted suicide was or should be legalized. In those cases, which fell within what lawyers call the margin of appreciation, in Nicholson, we proceeded on the basis that it was open to the British courts to make up their mind what was appropriate in the British context. We thought that as between the powers of the state, the legislature, executive, and the judicial system, in a case where we were making up our mind what in the domestic context European Convention rights meant, then the courts had a role. In Elan Kane, the Supreme Court has said that the courts don't have a Nicholson type role, so that Nicholson couldn't arise now directly. But it could possibly arise indirectly, and I just mentioned this briefly because if one passes legislation in a particular sphere, then the legislation needs to be fair and non-discriminatory. So one envisages, this is entirely speculative, but it's certainly, I think it's not a novel thought to envisage the possibility that someone may challenge this bill on the basis that it only deals with one class of sufferer, but there are others which are at least as bad, possibly on some view worse. So one, I suppose, it would be, I don't want to be cynical, but litigation is certainly possible in that area.
So just to pick up a couple of the concepts there, you say litigation is possible. We've got this idea of the margin of appreciation. So for those who don't deal with it every day of the week, that idea is that the European Court of Human Rights is a supranational court dealing with many, many countries and jurisdictions. And so it has a sort of hands-off approach where it says, this is your discretionary area, country A, country B. And there's not enough consensus around the Council of countries to decide that there is a common standard on the question of assisted dying. Is that a fair?
That's absolutely right. That's how the Strasbourg Court operates, and the United Kingdom has quite rightly welcomed it.
Yeah. And then at the United Kingdom level, there was also this question then of institutional competence. Whose job is it to decide questions of human rights around assisted dying? And on that, I'll just quote what you said, Lord Mance. You said, while the legislature is there to reflect the democratic will of the majority, legislature means parliament, the judiciary is there to protect minority interests and to ensure the fair and equal treatment of all. But in terms of where that left matters, at the time of Nicholson, there was the Faulkner Bill going through Parliament. And one view taken in Nicholson was that therefore UK judges should be hands-off and allow Parliament to determine the scope of these rights. So there's a sort of similar kind of principle to the margin of appreciation being taken by judges in respect to the role of Parliament.
Yes, absolutely. That is right. And the seeds of possible further litigation are inherent in the phrase I use, ensure the fair and equal treatment of all.
Yeah, that's right. Now, one of the comments of Lord Newberger, which you agreed with, was about the scope of the Faulkner Commission recommendations, which in 2014 were about Section 2, and the Faulkner Commission recommended, Lord Neuberger notes, that Section 2 should be cut down only to the extent that assistance could be accorded to those who were terminally ill with 12 months or less to live. And that's pertinent because that's what the current bill we're going to come on talk about in a moment is in the similar territory. It's only for the terminally ill. And Lord Neuberger in that case said that would not assist the applicants, wouldn't assist Nickinson and the others. Further, I find it a somewhat unsatisfactory suggestion. Quite apart from the notorious difficulty in assessing the life expectancy for the terminally ill, there seems to me to be significantly more justification in assisting people to die if they have the prospect of living for many years a life that they regarded as valueless, miserable, and often painful, than if they have only a few months left to live. So that observation is perhaps, again, at the root of what you're suggesting, that in a way, the terminally ill limitation is difficult to resolve from a legal perspective as a satisfactory limitation on the scope of the right to assisted dying.
Yes, well, I see the force of what Lord Neuberger said, and I think you said that I agreed with it. There is the other side of that coin could be that if you're dealing with someone who's going to die very shortly, the risks of getting a wrong decision might be thought to be less than in the case of someone who has a lifespan ahead of them, who might change their mind during the course and find that life was more rewarding. So I think most of these considerations can be thought of in different ways. There are people who have, I remember, who have thought of wishing to die and then have changed their mind.
Okay, so I think we've got a picture now of the existing situation. We've got the case law, with DPP guidance on. We're going to move to the next section, which is to look at what the new bill says. Anushka's got a guide, which if you could hand round to everyone now. I've summarised it. What I've tried to do in the summary, this will be sent to all of those of you online by email as well, is to translate everything that's in the Act into a more comprehensible set of steps as to what people will have to go through to go from a position of wanting help with dying to actually receiving the assistance. So the end point of all of this is that the new bill proposes that the doctor can provide to a person an approved substance which they can then take, which will end their life. So it's not going towards that possibility of a physician implementing or administering the drug. It is simply that they can hand it, as it were, provide it to the person who then would self-administer. So that's the end point. That's the total exception that is being brought in by this, that there will be an exemption from criminal liability for physicians who provide a drug following a very detailed and thorough process. So to get to that end point, I've broken it down. The first step is a preliminary discussion. You go to your GP and say, I'm thinking about it. And if the outcome of that is that you want to proceed, you make something called the first declaration. That's a signed declaration following a detailed conversation in the presence of the coordinating doctor and a witness. The coordinating doctor then makes an assessment, and they have to assess all sorts of things. They have to look at your medical records. They have to discuss diagnosis, prognosis, the treatment available, any palliative care. They have to discuss the complications that might arise from the drug, explain that at any time you can change your mind. They have to advise and inform the GP that they're requesting assistance to end their life, advise the person to inform their GP of that. And they have to determine a number of questions, whether the person is terminally ill, whether they have capacity, and then that they have understood what's what's involved. And if they have any doubts, then they do not go on to make what's called the next stage, the coordinating doctor's statement, but they can. There are other routes they can take where there are doubts, but they then have to make an official statement that confirms, one, the person is terminally ill. Now that means they have an inevitably progressive illness, disease, or medical condition which cannot be reversed by medical treatment. Their death can reasonably be expected within 6 months. The person is not terminally ill by reason of a mental disorder or by reason of a disability, and the person has capacity to make a decision to end their own life. And there are various other conditions. They have to be over 18, ordinary resident in England and Wales, registered with a doctor, and they have to have a clear, settled and informed wish to end their own life. And they have to have made the decision voluntarily and to have not been coerced or pressured by any other person into making it. So that's the first statement by what's called the coordinating doctor. There's then a period of 7 days called a period of reflection. After that, there is then a referral to an independent doctor for a second statement, second assessment and statement. Independent doctor has to look at all the same questions and make a statement of a similar kind to the first statement. All of these stages, if the doctor isn't satisfied, there are then processes potentially for a second opinion from another doctor. If you get through those stages, you remain settled in your voluntary intention. You've got 2 doctors, the coordinating doctor and the independent doctor. You can then make an application to the High Court. You make an application to the High Court, there's then a hearing in person, although that can be by video for obvious reasons if people are in offices and so on. And the court itself has to be satisfied of all of those matters again, that you're terminally ill, that you have capacity, you're aged over 18, you're ordinarily resident in England and Wales, that there's been no pressure or coercion. If the High Court then grants you, or you can appeal to the Court of Appeal if they don't, got a declaration, there is then a second period of reflection of 14 days. And after the second period of reflection, you make what's called the second declaration. So again, you fill out a prescribed form expressing your settled intention, and there has to be a doctor present around that. Again, they have to be satisfied you're terminally ill, no pressure, you have capacity, a clear and settled intention, and an informed wish. The coordinating doctor then has to make a second statement. And at that point, the coordinating doctor is then in a position to provide the approved substance. And at that point, again, there's a whole process of explanation and satisfying themselves that you understand what you're doing. And at that point, the approved substance can be given to you for self-administration, and that can be through a number of mechanisms or means. And upon provision of the substance, the coordinating doctor has to make a third statement. And then if it is administered, the doctor has to make a final statement. So there's an incredibly detailed process. The reality is it will take probably 2 or 3 months. If the courts can move very quickly, if the doctors can move very quickly, to go from the moment of first asking your GP to getting your 2 statements done and your High Court approval. I've footnoted that I've counted up on the footnote on the first page that I think there are 8 times at which you would have to make your decision or reaffirm it in a fairly formal context. Initial discussion with the doctor, first declaration, first period of reflection, instructing lawyers or making the High Court application yourself, go in front of the judge and reaffirm it, second period of reflection, making a second declaration, and then in actually administering the drug. So there are 8 occasions where you'll very formally have to think through whether you are wanting to go through with this. And there are 5 occasions when some formal professional authorization needs to be given: coordinating doctor's assessment and statement, independent doctor's assessment and statement, High Court judge hearing and declaration, and then during the coordinating doctor's provision of the approved substance. So one can see that there's an attempt to ensure that there is the most thorough process of consent available. So that's where we get to. Did you want to then, I think we'll open this section now. We've outlined it for everybody. It's only come out today. for some of the observations from the panel who've had a look at it. Who shall I start with? Lord Mance, you had an observation, I think, about the 6 months and the phraseology around the prognosis that is required for the terminally ill in section 1 or 2.
Yes. I simply was going to draw attention to the fact that the medical aspect, or purely medical aspect of the certification, as regards the time within which the sufferer is expected to die, is phrased as follows: that the person's death in consequence of that illness, disease, or medical condition can reasonably be expected within 6 months. That is a fairly flexible test, it seems to me, at first sight. Obviously, courts will have to decide what it means in fact, but one's initial impression is that it is quite a flexible test. And if doctors express themselves in terms of she or he can be expected to die within 3 to 9 months, or within 3 to 12 months, or within 3 to 7 months, which of those would suffice? And all or any of them, those are questions which would have to be considered.
Fiona, I know you've looked quite a lot of depth about the Health and Social Care Committee report that's in the background to this. Do you want to help us with any of the thinking behind some of the provisions and the safeguards that we came through?
Well, I think the Health and Social Care Committee undertook quite a lengthy investigation at which it expressly said we're not going to reach a view one way or another. We're just going to look at what the position is. What they basically found was that in most other jurisdictions, there are a series of safeguards, whether one adopts the approach which is adopted in this bill, which is only those who are terminally ill, or whether one adopts a wider approach, which is the case in Canada and in other jurisdictions, which is one of intolerable suffering, whether or not death is imminent. And however, they did find was that if you ask clinicians what their view is, although about 50% of those surveyed by the BMA in 2020 were in favour of assisted, of being able to do this, that was significantly less for those engaged in geriatric or palliative care. So in reality, the people that you might be asking, or the people who may most obviously be the ones that you would go to, are the ones who are least likely to wish to do so. And the bill, quite properly, every jurisdiction in the world which has introduced this has a conscience clause, which says, as a clinician, you don't have to do this. And I think, you know, it would be wrong not to say that because of all those factors. What the committee report does say is obviously a lot of the arguments against this are a sort of slippery slope argument, which is if one has it for terminal illness, then it will gradually be for everyone. And they will point to examples of, for example, Canada or Belgium or Holland, which have much wider bases for that. And what they have said is, looking at the statistical analysis, anyone who has introduced assisted dying for terminal illness has not then changed it to unbearable suffering. So there tends to be two regimes, and once one regime goes in, it doesn't necessarily move. The other factor, often raised by people who have concerns quite properly about such a bill, is that it will prevent the extension of palliative and end-of-life care services. And what the committee found was, in fact, quite the contrary. What tended to happen is that palliative care services improved, at least in some jurisdictions, because of the need, as is identified. I mean, again, every jurisdiction I've looked at, and I've tried to look at the sort of French and German bills which have been going through Parliament as well, they all have, you have to discuss what the alternatives are by way of psychological support, palliative care, etc., etc. So in some ways, it brings palliative care far up the agenda. You know, if you speak to palliative care doctors, they would say, it's not high enough up the agenda. So in some ways, having a system whereby there has to be really significant thought given to that process may well provide an impetus for us as a society, as this is a societal issue, to improve the provision of palliative care more generally.
Rebecca, as someone who's contemplating going through the process, or having that breakdown of what's proposed, how does that strike you as a set of safeguards in terms of the balance between ensuring consent, ensuring that there is no coercion or pressure? On the other hand, it does seem quite a detailed bureaucratic set of processes.
That's a lovely way of putting it. I would have said it's bloody lengthy and exhausting. And my mum, who is form phobic, would absolutely have been stopped in her tracks by that. I mean, what we always say is that having cancer is tiring, knowing that you're dying is tiring, dealing with all the doctors around it is tiring, let alone having to convince people or talk to people endlessly about dying. She has not wanted to be part of this campaign for personal reasons, but she finds herself in the center of it because of what is happening. It is safeguarded to the maximum. It feels like it's a really strong, safer bill than I ever anticipated. It doesn't necessarily take into account things like how it's going to feel for the patient, the family, and the doctors. As you say, my sister-in-law is a consultant geriatrician. She is very against this. She's worried about multidisciplinary clinicians who are looking after older people at the end of their lives, not having the value focused on them. But I keep trying to tell her about the committee report, as you've just really eruditely said, that it gets better. So that was really reassuring for us. But I must say, even when you just read that out, I just started shaking my head at the processes that we would have to go through when someone has a terminal illness and they're exhausted anyway. I mean, it's enough that she has to go to oncology, however often she has to go, let alone all these processes. I understand why they have to be there, but I'm not sure the personal experience has been taken into account.
Can I bring in David Locke now? Because I think, David, leads into what you've been looking at around consent processes. Do you want to sort of address us on that? I'm sorry to bring you in so late, but it's hard to.
No, not at all, Alex. Can I apologise to everyone that I'm not with you? I'm on a judicial studies course. I bring my experience of having been on the BMA Ethics Committee for 10 years, and we've discussed physician-assisted dying on numerous occasions. I also bring the thought that in short talks like this, there's probably only 3 things that anyone will remember that I'm going to say. And so I'm going to keep it very, very simple. Next slide, please. The first thing to say is that there are a huge variety of ethical views on physician-assisted dying. By and large, palliative care doctors are against it because they're worried that it will divert the attention away from palliative care towards assisted dying as an alternative. So the first thing I want to say is ethicists are no more in agreement about physician-assisted dying than anybody else. There's general agreements on the importance of autonomy as a central ethical principle, but there's simply no agreement on the extent to which anyone can exercise their autonomy to choose how and when they end their own life, or what safeguards are needed to protect the vulnerable. And therefore, to that extent, the ethicists have individual views, but really this is a political judgment issue. Next slide, please. The one thing that I got enormously out of the ethical debate is to understand that there is a clash between autonomy and a duty of care, because autonomy is the right for people. That might be something as stupid as going paragliding, playing rugby, going rock climbing without a rope, all of which are dangerous, or not to have medical treatment that the doctors advise. And the general consensus, the ethical consensus, I think the same position in law, is that for people with capacity, where there is a conflict between autonomy and duty of care, autonomy wins. So no one can say, because I have a duty of care to you, I'm not going to allow you to do something that you autonomously want to do. And I think the ethical principle is that if autonomy trumps duty of care in life, why should it be any different when it comes to the autonomous right to end a life? And I've never had a particularly satisfactory answer. This is all about choice. It's not about forcing anything on anybody, but effectively the present law reduces our autonomy by reducing the ability to make choices at the end of life. And the only exemptions seem to be justifiable in ethical terms are those with mental health conditions and possibly those in the custody of the state. Next slide, please. The next point that comes up very quickly from the Ethics Committee is that doctors shouldn't be compelled to assist in physician-assisted dying, because doctors have ethical views like everybody else, and no doctor should be obliged to take any part in this process. There is a potential issue arising from the bill, which is the only doctors that can take part in any of the processes are those who have had training in a form approved by the Secretary of State. And so in order to take part in the process as anticipated by this bill, a doctor will have to presumably pay themselves to go through a fairly intensive training program. And then in presumably the doctor's own time, they will have to undertake these substantial functions. They will undoubtedly have to be properly insured for it. I think it's unlikely that this is going to be delivered as part of NHS funded care. So that, and particularly if it then needs to be an application to the High Court, there must be a concern that the cost means that as presently structured, this is an option for the wealthy, for the engaged, but not an option for most people. That's an issue which no doubt will have to be discussed. Next slide, please. The other issue that Alex asked me to talk about is I'm a member of the Human Tissue Authority. And we have in this country a system for checking the validity of consent processes for important medical procedures. And that arises in inter vivos, that is for living people, organ transplants, which are regulated under the Human Tissue Act 2004 and under regulations made under that act. And the system we have is, I think, worth examining in the context of physician-assisted dying, because it's an independent assessment process to prove genuine consent, no pressure, and no reward. Next slide, please. And the process that's developed is that an independent assessment is carried out of each person by an independent assessor. So it's an inquisitorial process who is trained and accredited by the HTA, Human Tissue Authority. And the independent assessor interviews the donor and recipient separately, and together on behalf of the HTA, it's independent of the healthcare teams who are involved in the process. And then a living donor coordinator will organize the interview and make sure that the evidence is there to satisfy the independent assessor who writes a report as to whether or not the person is genuinely consenting to, normally it's kidneys, because we have 2 kidneys, we can survive with 1. The offer to give up a kidney is by somebody who understands the medical issues and is freely and without any pressure or reward making the offer. Next slide, please. And this interview process leads to the independent assessor making a detailed report, which then comes to members of the Human Tissue Authority, and I'm a member. And we then read the reports and carefully consider whether we're satisfied, and if so, we sign off, and there is a process. and then legal approval is given for the clinicians to carry out the medical process. That investigative process is working well, it's thorough, and it might be a model which provides greater reassurance and greater access than requiring somebody to have the capacity to go to the High Court. But that's an issue for the politicians.
Yeah,
But there is another model.
Let's pick up that issue, David, about judicial oversight and other models. The judicial oversight idea, I think, has been adapted from the Nicholson judgment, where it was endorsed by Lady Hale and Lord Mance and Lord Neuberger and possibly others, as a means of securing that people were not being coerced, pressured, and that they were freely making these decisions. I wonder whether something like what you're talking about need not be the mechanism, David, for consent, whether it might be a mechanism for supplying evidence to ensure that decisions, that the High Court could then say, we're happy that these decisions are being made freely without coercion on an informed basis. So I wonder whether it's perhaps something that fits in with the framework of the bill as a means of securing evidence for consent.
I mean, let me put my hand up and declare I sit as a Deputy High Court Judge in the Family Division. So if this bill came through, it's the sort of cases that would come before the court, just as, for example, deprivation of liberty cases come before the court. The bill provides for rules of court to be made. There's no reason why why there couldn't be an independent assessment process with trained assessors supporting the court application. I worry about the capacity issues for the court. The judges are already fantastically busy. I'm also concerned about the degree of scrutiny that judges could really apply in these circumstances. I doubt it's appropriate for a hearing where the person gives evidence before a High Court judge to convince them they're free in capacity, in which case it's going to be a purely paper exercise. How does the judge satisfy himself or herself that what the paper is saying is genuine? With the human tissue model, we know it's investigated by somebody who's trained and is asking questions, and there's an evidence trail. And if, for example, the donor and the donee say they've been friends for 20 years, you know, there's evidence of 20 years, photographs and emails and everything. Whereas in the model that where doctors are doing the investigating, doctors are not trained investigators. They're not necessarily looking for that sort of evidence. So there's some questions.
Yeah, thanks, David. We've got two other people who've sat as judges at one point or another. I don't know if they want to think about that role of the judiciary.
Well, I think Lord Mance should go first, given his role as a previous member of the Supreme Court.
Yes, but I'm not sure that my experience makes me the best qualified person to speak. I think that the points which have been raised about in this connection are entirely valid, but and part of the debate. Certainly my colleague, Lord Wilson, and Lady Hale, of course, with far greater experience than mine in this area, were confident that a judge-based approach would work. I'm not sure that they contemplated that there would be so much doctor-based involvement at the previous stages, and as has been pointed out, this makes it a complex scheme, to say the least, and whether doctors are the right people to judge some of the questions, I mean, including not just the question of capacity, but also whether someone's been ordinarily resident for 12 months, or even has a clear, settled and informed wish and has not been coerced or pressurized. That involves some quite non-medical, potentially quite non-medical considerations. So I think some have suggested perhaps there should be a more broadly based involvement at the earlier stage, involving different disciplines, which would then move up to a judicial level. But I would have thought, bearing in mind what Lord Wilson and Lady Hale say about judicial involvement in very sensitive decisions of life and death, that there is a potential role for a court there, as indeed Lord Newberger and I and others said. But it's certainly one that needs some further working out as to whether it fits on top of a medically based set of preliminaries.
Most other jurisdictions, there
Around the world.
Yes, in most other jurisdictions around the world, in some other jurisdictions, there is judicial oversight, but in the vast majority of them, there is none. There is a body, usually a multidisciplinary body made up of, Australia's probably the best example of this, where you've got palliative care experts, lawyers, doctors, people from civil society, people who have disabilities, who are the people who sort of review the applications and say yay or nay. I'm just thinking, I completely agree with Lord Mance that the family division makes decisions every day as to whether people have capacity, whether or not they're ordinarily resident, and their clear, settled and informed wishes. So those factors would not be difficult. I just question if this is something which we as a society are going to do, and it's about people who have capacity. I can understand if there's a question about someone's capacity, you would refer it to a judge to make an ultimate decision. But in these sorts of cases, would it not be better to have a multidisciplinary body in a way to get buy-in from all the different parts of society who would need to be part of the process? And in particular, I'm thinking about those who live with chronic illnesses, who could have a very valuable insight into decision-making and into issues of coercion and duress and things like that, both positive and negative.
We're going to have questions in a minute. So I've got 3 online, I think, at the moment. Send them through if you've got others. And then we'll ask some from the floor. So pick them up. But before we do that, one last topic, Fiona, I know you wants to cover is Professor Chris Whitty.
Well, at the moment, the idea, I think, is going to be that the chief medical officer will have to be notified of all these factors, and then he will have to produce an annual report, him and the chief medical officer for Wales. So I think the idea is meant to be, from the way that the legislation is currently structured, is there'll be a set of regulations which will say, you shall send to Chris Whitty, or the Office of the Chief Medical Officer, you know, at every step. I query and question, given the many and multiple roles that the estimable chief medical officer undertakes, whether or not he practically could do so. The chief medical officer's secretariat is incredibly small, so we're not talking about a great big organisation. And whether or not, given that he performs a number of roles, but one of them is the nation's chief doctor, whether or not, given that this is an issue upon which doctors are not unanimously agreed, whether he's the right person to lead that. I mean, I've got no doubt he has the clinical skills, ability and judgment to organise that, but I just don't know whether or not in other circumstances, as David's identified, there have been specific bodies set up, like the Human Tissue Authority, whose job it is to look at these things, possibly under the auspices and control ultimately of the Department of Health or of other individuals. I just think that that might be a better way forward.
Okay, well, it's not a huge principal issue.
No, it's
but
not an
the
in-principle
review.
issue, it's a practical issue though.
Yeah. And it's going to go to the Secretary of State to consider after 5 years, is on the face of the bill at the moment, is to report back to Parliament after 5 years.
But again, that's not unusual. Most of the legislatures that have introduced it, certainly in Australia, Canada, common law jurisdictions, have had a 5-year review.
Okay. All right, so that takes us to our hour and time for any questions. Are there any in the room? Anyone? Wait, let me see. Yeah.
Hi, my name is Fiona Scolding. I'm a trustee of Dignity and Health. This is an interest, particularly. And I wondered if we could come back to the question about the way the law is framed and the any risk that might be inherent in it of a potential challenge to broaden its scope beyond terminal illness longer than suffering. Because I think we have seen some arguments, most of which have preceded the publication of the bill, so they've sort of been conducted in a bit of a vacuum. But we've seen some arguments that you alluded to, Lord Mance, that there is the risk that the bill could be challenged in a ground of discriminatory. But what I don't think we had a discussion of, or I would like to see more discussion of, not in this room, but in you know, discussion more broadly, is actually what the prospects of success of that are. Because I think it's one of the things identified a procedural risk, but I think we can all concede that all of the procedural risk, but you know, how it can be brought to legislation, and then ultimately you could go to Strasbourg. But actually, from my perspective, it feels like there is a very broad market of appreciation in the area of assisted dying, and so there ought to be. And Strasbourg Court has shown no interest in trying to tread on the toes of.
Okay, thanks.
foreigners.
Yeah,
So I
well,
just wondered if
we'll
you
answer that in
could-
1 second. I just want to hear the other question.
Yeah.
And then I know Fiona's looked at the most recent Strasbourg law as well, so we can circle back. I just want to, so that we've got time to think them through. Let's take three at once, and then, so gentleman there, who are you and what's your question? Yes. Yeah. What's your name?
Yeah.
Yes. No, your hand's up.
Yeah.
Yeah. What's your name? Yeah.
I'm Flacco, I'm a barrister.
Yeah.
It's what the panel thinks the practicalities of the assessing the coercion and pressure test are going to be. Because we've heard a couple of suggestions for alternative systems, the tissue example, the multidisciplinary practice example, but they're not what the bill's gone for. And we opened, I think, with an explanation of how at the moment the CPS investigates a year and a half. About 1 in 20 go to prosecution. But I mean, as you said, there's a lot of stages, but most of them, it's just a question as to asking the applicant. They're presumably not going to say, I've been put under pressure to ask to die, at least not many of them. How are the doctors supposed to assess this? And I mean, we've been told the court family division is used to this, but the family division is used to this in kind of day-long periods with adversarial representation.
Okay, understood. Yeah. Okay, so let's circle back to the first question. Fiona, I think you've looked more recently at the question of
Yeah,
any evolution or margin of appreciation. So
well,
remind you, that's Strasbourg saying we'll leave it to member states to decide on this issue.
the most recent decision by the European court was in June this year, which was a case involving Hungary. And that was about somebody who had ALS, which is a form of motor neuron. And the court said, again, no, we are not going to interfere because of the margin of appreciation. But what it interestingly also said is that although there was a growing trend towards it, the majority of member states in the Council of Europe still do not approve it. It does say, however, and uses what those of us who practice in this area know, that the convention must be interpreted in the light of changing circumstances, and so legal measures should be kept under review. So I think what it's saying is potentially, and I think this is only potentially, if a majority of states within the Council of Europe were to adopt it, the court may and only may reconsider the matter. But I think that is highly unlikely. I suspect that you would get to 50% in any realistic time soon, given who some of the other member states are within the Council of Europe, who would have strong and principled.
Given how few already there are, I mean.
Well, I mean, there are more than there were. I mean, there's Spain, there's Portugal, there's France and Germany have both got kind of bills on the go, which will pass. There's Holland, there's Belgium, there's Switzerland. So it's not, it even in the past 6 or 7 years, there has been a noticeable increase in the number of jurisdictions. So I suppose it depends whether the rest of Europe follows the lead in those kind of Western European countries. But I can see some countries like Italy, I can't imagine that it would happen there anytime soon, if I put it that way.
Okay, so that's margin of appreciation. We don't think it's likely anyone's going to be able to go off to Strasbourg and try and expand the ambit of a terminally ill dying provision. Then we've got this other issue that came up in Nickinson about institutional competence. Where does that factor in under a sort of Article 14 discrimination challenge? So if someone comes along and says, well, you've interfered, I'm in a similar sort of position, I should also be allowed to die. What are the UK courts likely to say about that? Do you have any thoughts?
I think it would be unwise for me to engage in prediction about what my former colleagues or present court would say, but some of the considerations have already been very amply laid out, and quite clearly one can always envisage challenges, but they don't always succeed.
Yeah. Well, yeah, and I think it's fair to say none of them have, even under Article 8, and you might think that Article 14 has a broader institutional competence sort of set off by the courts as in terms of letting Parliament do the work. I wonder, David, if we could bring you in, did you want to say anything on the second question about the practicalities of consent? We've talked a bit about it, but
Well, just on the first point, I mean, the most the courts could do is issue a declaration of incompatibility, because we're dealing with primary legislation here, and therefore the courts are properly hobbled in telling Parliament what to do. So the most that could happen is that the courts would say, well, this is something Parliament should go away and think about again. Whether they would do that or not, of course, depends on the circumstances, depends on the justification for the difference. But if the justification is this is broad political judgment area, then I suspect the courts will give Parliament a very wide margin to decide where to draw the line. The second issue, I think, is really important, based on the experience of the HTA and precisely what they're looking at, which is who is going to do the investigation to talk to the relatives, to talk to the people behind the individual, to check there is no coercion. You know, where there's a will, there's a relative, you know, a lot of people who will have an interest in this, and that's why the process from the HTA is so thorough. And I think it's a legitimate question Parliament will have to ask itself as to in what way it builds in some form of investigation, which is not a role for doctors. I think the questioner is right. It's not a role for doctors. It's not a role certainly for police officers. But somebody needs to be talking to the relatives, to the people who are affected, to check that this is not an inappropriate situation. How that's done, I don't know, unless you adopt something like the HTA model.
we're going to stop very promptly in a couple of minutes, because I know I promised Lord Mance we finish at 1:45, so we'll finish a minute ahead of that. We'll take the last question here.
So related to this whole question about how to investigate, the bill deals also with criminal liability. Is there something unusual here that the doctor involved who acts in good faith, but maybe negligent because they haven't taken all the steps that nobody yet knows how they should pay, might be criminally liable? Is that an unusual thing?
I don't think that's right. I think, and I'm not sure they would be criminally liable. I think they're exempted from criminal liability or civil liability.
Unless they're acting in bad faith. I think there's a bad faith exception.
So they're in good faith or without negligence?
Yeah.
But if the negligence is a low threshold, no?
So they wouldn't be criminally liable, and then there's an exemption for civil liability as well.
I mean, there is, however, as I noted, introduced into the Act will be two new offences. The offence of dishonesty, which, you know, if somebody dishonestly makes the declaration, they could get 14 years in prison. If, however, they falsify or destroy documents, they could in fact get a whole life sentence. Well, a life sentence, sorry, not a whole life sentence. That's the incorrect use of terminology.
All right, so is there any final words anyone wants to say before we
I just want to say thank you for letting me be a part of this. It's been so insightful and a massive lesson in how much work I need to do to improve my brain.
All right, I'll try and answer some of the online comments now online, but I do want to just finish this on time. So thanks very much, Lord Mance, for coming and giving us your insights and expertise.
Thank you.
Thank you very much, Rebecca Wilcox, for coming and giving us your perspective from the campaign side. Thanks to those who made it in person, and thanks particularly to Fiona and to David Locke for their expertise as well. It's been very wonderful. Okay, we'll wrap it up there. Thanks very much.